So the meta chat back channel producer is the crazy one. You'll see her on the chat. If you've got any questions, and I expect many questions this evening because we're going to cover some pretty interesting grounds, send your messages, questions to her, and we'll see them in my chat window, and off we'll go. There might be some strange audio and video sync issues this evening. I'm still trying to work out what they are. The important thing is we have good quality audio. The video might be a little bit strange. Now, a common request from most of our viewers is they do want to see the cats. I'll just point out that our cats now have an agent. So therefore, they have a rider. The rider is cat food. So I've bought some cat food with me, and I'm just going to move the camera here a little bit without breaking said camera, so you can see one of the cats, because the cats have decided that it's sleepy time. So, cat, here's your payment. Thank you very much. And just pop that there, and we'll continue on. Okay, so I'd also like to thank First Dog on the Moon for my t-shirt, or Crikey t-shirt. I'm having a Jeanette of a day, and that's Jasper the cat. If you need an explanation, at First Dog on the Moon will help explain that, but it also sort of ties into tonight's theme as far as talking about politics and the law and that sort of stuff. Before I get on to that, two things. Firstly, the zombie guinea pig flu. Earlier this evening I had a chat to one of my old work colleagues, Emma Klein. She's got two kids. She's a mum of two kids, both under 5. And she got a letter yesterday about whooping cough in her son's daycare. And she referred me to a story from The World Today, which is an ABC radio show from the 11th of March this year. Meredith Griffiths, in her report said, so this is 6 weeks ago from now, said a baby had died from whooping cough in New South Wales, the first such death in 8 years. Dr. McNulty, Director of Communicable Diseases of New South Wales Health, says that there have been more than 3,000 cases of whooping cough in the first 2 months of this year, compared with just 450 in the same period last year. And the last outbreak of whooping cough was 1997, when 9 people died Australia-wide. So when you sort of put this in context with the swine and the pig flu, or whatever the zombie guinea pig flu, whatever you want to call it, why the whooping cough thing, which is very dangerous, especially to young kids, and causes brain damage if you're older with the oxygen stuff, it just astounds me what the media just doesn't understand, doesn't get it, or puts things out in the wrong context. And also, a quick recap on last week's The Lost Uncles. One thing I forgot to mention last week was another thing that destroyed my brain as far as the Anzac Day is concerned, was a play we studied in 1983 called One Day of the Year, which I'll let you go and do some research on. And it certainly infected many minds, I think, in understanding what Anzac Day really means. Also, a strange observation that we're looking at the chat from last week. It seems most of you are actually listening rather than having a good old chin wag about, the colour of my hat or hair, which I'm actually humbled. So I thank you for listening. That's the idea here, to learn something and to listen. So the show tonight really stems from the Anzac Day stuff, and one of the things I learnt on Twitter, Twitter's a great educational environment, got a lot of smart people there, is understanding or finding out that the ultimate power over the Australian military comes not from the Prime Minister or the Cabinet, but from the Governor-General, which just blew my mind. Maybe I should have known this, but I certainly didn't. And the person that enlightened me of this is Mr. Peter Back. So to help me through my personal constitutional crisis, I have on the line here, I'm just going to pop Peter on the screen, is Mr. Peter Black. Hi, Peter.
Hi, Nick.
So you're calling in from Queensland?
Absolutely.
Wow, these internet things are wonderful.
It's amazing, isn't it?
And you're in your office?
In my office, yes, working late on a Thursday night.
Yeah, that sounds pretty typical for us, sort of type A personality style peoples. I'm just going to, okay. Just going to go, just make sure that all the audio is working all right. Seems all right. Okay, so Peter, what do you do?
I'm a lecturer in law here at the Queensland University of Technology. So one of the hats that I wear is as a lecturer and teacher of constitutional law, and then the other hat that I sort of wear is the lecturer and researcher in internet law.
Okay, so I sort of first met you when you were doing the internet IT IP sort of stuff, and you've now moved into the constitutional law. Is that because you like constitutional law more? Does that sort of get you up in the morning more?
I mean, I'm pretty passionate about both of them, to be honest. I mean, I've always had a real sort of love of government and politics, and constitutional law is an unbelievably exciting and challenging area of law. And so, as I sort of evolve in my career, I suppose, really want to sink my teeth into something that is substantive. And constitutional law is sort of the perfect doctrinal place to do that.
So, as sort of in my quick reading and learning over the last couple of days, and I just might point out that I studied two books heavily. One was Federation: The Secret Story by Bob Birrell, which is I actually read it. There's one whole chapter of it the second time round to get some of the historical context. And secondly, this book edited by Michelle Grattan called Australian Prime Ministers. I'm just going to cover up the picture of John Howard so no one laughs. But so just to get some history, certainly on the first couple of Prime Ministers of Australia, Edmund Barton and Deakin, because they had a lot to do with the Constitution in its formation. So just to try and prove to you, Peter, that I should at least get an A+ for this assignment. Not that I'm in your class.
We'll see.
Okay. Okay, so obviously there are different sort of specialities in law. There's contract law, criminal law, corporate law. They all start with C for some reason. What you said that constitutional law was juicier and more interesting. What sort of makes it that way?
It's just the idea that this is for me, I see it as a higher law because it's the law that applies to our government, and I don't think we can get any more important than that.
So
and
it's
the
about
fact
the
that
government,
it then,
how it's
and the fact that it then permeates throughout all the rest of our legal system.
Okay, and I'll get to some of the history of the Constitution, the stuff of the Constitution in a moment. But by its formation, you mean the federal government and states, how we have an upper and lower house, how we have a high court, and that's what you mean by the formation of government.
Yeah, that's right.
And can you tell, now obviously you have constitutional law students, is there a physical or is there a difference? Can you pick a constitutional law student versus, say, a corporation law student? Or is that a question you may not wish to answer on
well, I mean, constitutional law is one of the compulsory subjects, as is corporate law. So every student does have to go through and study these particular areas of law. I'm not sure if you could necessarily pick a difference. You'd probably find that the corporate lawyers come to class dressed in suits. The constitutional lawyers don't.
But they wouldn't come in robes either, and wigs.
No, they wouldn't come in robes with wigs either, no.
And one of the questions, which is actually not related to law, is you're a very prolific, person as far as using IT is concerned. You do online chats and podcasts, as we see in the Twitter stream. You're on Twitter. You don't seem to sleep. Does QUT have some clear guidelines for the way you interact online?
No, is the simple answer. And I mean, there's a policy for how you use sort of the internal blogs and internal wikis and those sorts of things, but not as far as our interaction with the outside world goes, which is something that I'm sort of aware of, because I'm also stuck, unfortunately, with having QUT in my username, which is, historical accident. I'm Peter Black QUT on Twitter and everywhere else, which wasn't, by design. It just happened that way. But so I'm aware that in a way I'm sort of representing QUT, so I'm sort of cognizant of that. But I know other people around here have been asked to close down various blogs and Twitter accounts if they say something. For example, there was the QUT Lolly Shop was on Twitter, and the owner of the QUT Lolly Shop used to, as well as pimping his product, his lollies, used to engage in all sorts of political commentary on Twitter as well. and the university had a problem with that, and he had to shut down that particular Twitter account.
That's interesting. Yeah, so maybe a discussion, for another day when we
Yeah.
talk about policies and that sort of stuff. But it was just an interesting question because there are some people who are prolific that don't have that the safety net underneath them that catches them and they know where they stand. And
Yeah.
yeah, it's interesting. Uh, So let's start with let's go back to the Constitution. A little bit of civic history. So Australia's made up of states, and
Yep.
these were colonised and incorporated through different things. So New South Wales, they brought lots of convicts and started here, and Queensland was sort of convicts that couldn't settle in New South Wales, and same with Tasmania. South Australia was set up as a company, like an incorporated company, but started as a state. And so we had these separate sort of states growing till they physically, grew to cover all of Australia, physically, the whole continent. And there was a push to nationalise Australia, make it a nation, from 1880. And one of the key people behind this was Sir Henry Parkes, a New South Wales Premier, or Premier of New South Wales. And there's a famous speech, called the Tenterfield Oration, where he uses the different railway gauges around Australia as a drive to say we've got to make a real country out of ourselves. We can't deal with this stupidity anymore. Now, the whole concept of federation, you'll see why this is important in a moment as far as constitution is concerned, stalled in the 1880s because we had an economic depression or a recession, which actually sent one of our key actors that I'll be talking about in a moment, Sir Edmund Barton, almost sent him broke. But then, after the depression lifted, and in 1892, there was much more of a populist move to federate and create our own nation. So Sir Edmund Barton, I don't think he was Sir at that time, but certainly Edmund Barton was a private citizen at that time. He wasn't in politics, but basically was one of the people who led the drive to create a constitution and to nationalise. Also, at the same time, historically, we had the rise of labour movement, so people joining into unions and, labour versus capital sort of stuff, which has an impact a little bit on the Constitution. So throughout the 1890s, we had conferences. People got together and drafted a constitution that all states would be happy with. And as you'd expect, there are lots of interstate rivalry. So New South Wales was very much a free trade state. They wanted to freely trade with the rest of the other states without imports and tariffs. And I'll let you go and read the histories why that is. Victoria wanted protectionism for some of its industry, so it was very much more sort of set up against New South Wales. And other states like South Australia, Western Australia and Tasmania were very much parochial. They just wanted to make sure that the big East Coast states, this might sound very familiar, didn't take over the whole running of the country. They wanted their voice, which led to what's in the Senate and a few other things. Also, I might note that in Brisbane, when the referendum was held to say whether we should be federated and use a constitution, Queensland, specifically Brisbane, was not in favour. I think there was a 68% vote against federating, which I found quite interesting.
We were always a bit contrary up here.
Yeah, well, we might get into that a little bit later as well, but we won't blame all Queenslanders. And I'm from South Australia, sort of, so I'm sort of a bit of a bitzer. So yeah, we'll leave state parochialism alone just for the moment. What I also found interesting, Peter, is that New Zealand attended some of the first conferences in the early 1890s.
Yeah, that's right. There was some serious discussion as to whether New Zealand would actually form part of our federation. In fact, it's sort of there's a couple of historical anomalies in the actual act of the British Parliament that gave effect to our constitution. So, in for example, Section 6 of the Constitution Act that was passed by the UK Parliament, it lists the states of the Commonwealth, and the states that it lists are New South Wales, New Zealand, Queensland, Tasmania, Victoria, Western Australia and South Australia. So, even right up to the last moment, there was some discussion as to whether New Zealand would actually be part of it.
Which I find amazing. Now, one of the things that, having been to New Zealand and actually fairly much in love with the country, is that they have this treaty between the Maoris and the the white people, which has a name which just fell out of my head, and someone on the chat stream will put it in, I'm sure. The Pakeha, that's right. That was written in the 1860s, and there, if you go to the Te Papa in Wellington, you see there's a whole section on the Treaty of Waitangi. Was that one of the reasons why New Zealand decided not to become a part of the Constitution, part of the Federation, I should say?
I think that was one of the factors. I think there were a range of different factors, but a lot of them, I think, also just came out of a separate sense of identity. Whereas with the Australian colonies, we still did have that, general feeling that we were together. New Zealand was always, despite, the geographical closeness, just had a little bit of a different sort of take on things. So I think it was more that, the different sense of identity more than any particular issue in terms of relationships with Indigenous peoples.
Yep. Which is also another whole topic of constitutional law we may get to this evening, which is interesting in and of itself. Now, when they formed and were writing the Constitution, so they did this before it was, we were federated and were separate, quote unquote, from the UK or from Britain, is that they neglected to really describe reserve powers, and there were lots of assumptions made about powers and conventions and things. So why didn't they, document everything? They're lawyers. Everything gets documented. I know a lot of lawyers that want to write everything down.
True. Mainly because they saw that they were inheriting, the British system. They really saw that they were just creating a nation on that foundation. And the Constitution of Great Britain is not even a formally written down document. It's made up of numerous different acts of parliament and built upon layers and layers of history and tradition and convention. And so those same sorts of conventions which emerged in Westminster were just always seen as being part of the foundation, the starting point for Australia's constitutional system.
And I noticed when I read the history that they purposely neglected to do it. So there were arguments in some of the constitutional conventions about whether they should or shouldn't write some things in, which I also found amazing. In terms of, when it comes to, looking at constitutional legal issues, are there any reserve powers or, unwritten things or, external to Australia things that the High Court looks at? And I'll get into some of the mechanics a bit later. But just whilst we're on this topic of reserve powers, do they look outside of Australia to look at these sorts of things, the UK laws and that sort of stuff? Or am I completely out of my tree?
I mean, it's not a matter of the reserve powers really coming up before the court in terms of something for them to consider. The fact that they're not written means that they're really are just based on conventions, so they're not really subject to judicial interpretation in that way. But certainly when you're looking at how the system operates, you need to be able to go back and have a look at how things operated in, the United Kingdom prior to federation, and also how things operate there. Because if you don't have that, basic background, it's, it could be able to make sense of our system, because large parts of it aren't written down anywhere.
So in terms of, just outside of the Constitution, our legal system comes from, obviously, the UK system, which is, the concept of both written down laws, but also common laws. So that's the interpretation of those laws which set precedents, which future case or future judgments are based on. Am I correct in thinking that? Or
yeah, no, that's right. That? No, that's right. Yep.
Just goes to show that little section in my MBA I did on law is actually stuck, even though I only got 50% for that. It was but it was the section I actually enjoyed the most. Okay, so in the latter part of the 1890s, there was state-based referendums where each of the states voted about whether they wanted to join the Federation or not. Now, I didn't actually clearly read this, but at that time, women weren't allowed to vote, were they, Peter?
That's right. Women didn't have any say.
And only white men could vote.
That's right.
So essentially the referendum could be argued to be not a true representative of what people were thinking at that time, in today's context.
In today's context, yes, that's right. We don't actually know how, the women or other groups would have voted if they indeed have the ability to. But yeah, you could make that argument.
So On to my favourite state, Western Australia. I love my Western Australian people. They were the last state into the Constitution and also joining the Federation. What was up with the sand gropers, with the Western Australians?
Oh, well, they were just having a bit of a discussion as to whether they wanted to do their own thing or whether they just wanted to remain as a colony of Great Britain. It's the same sort of thing that we see with, WA and Queensland today, sort of a bit of an independent streak that was there. And so it took, the WA a while before they decided to come on board. Again, if you go back to that, the act of the British Parliament that passed our constitution, the preamble to it omits Western Australia. It talks about the people of New South Wales, Victoria, South Australia, Queensland and Tasmania. It doesn't include WA in that list because when they were drafting this act that gave effect to our constitution, it wasn't clear if WA was going to join yet.
So, just whilst we're on Western Australia and their independence streak, I believe in 1934 they held another referendum, and this referendum was whether they should, leave the Commonwealth of Australia, the Federation of Australia, the Federated States, and rejoin the British Empire. And they actually said 68% of the people voted yes.
Yeah.
Is that correct?
I'm not actually sure on the result of it. I certainly know that they did have that vote. Yeah.
I just found that absolutely surprising, and it really helps explain when I go to Western Australia why. Or it doesn't help explain, but you certainly see the antagonism to the eastern states when Western Australia, has a lot. Basically, apart from the half that is already dug up and sent to China,
yep.
The part that's still left is still there. So, if I owned some land, let's say in the middle of New South Wales, and I was just Jack of Australia, and wanted to create my own country, could I do that?
I mean, yes. Yes, you could. Whether anyone would, bother to recognise you as a nation state is a totally different question. But yeah, you certainly could give that a go. But I don't think you're going to see too many other countries around the world recognise that. And nor will you find that the Australian government will recognise that either. They'll still want you to pay tax.
Which is funny as well. They always want their money somewhere, which is actually a lot of what the Constitution's about. So essentially,
just on that point,
yeah.
I think that is a really good point. You've sort of spoken about the history there, this move to nationhood, the fact that there were the protectionist movements and all of that was part of the debate. So much of what was the drive behind federation, was financial and were those sorts of concerns, not out of any huge, strong quest for our freedom or anything like that. And that's why when you look at our constitution, a lot of what's contained in there does deal with money in terms of how things are going to be divided between the Commonwealth and the states. And we don't see in our constitution, like you see in lots of other constitutions around the world, extensive bills of rights or whatever, because we weren't, fighting for our freedom. We weren't rebelling against United Kingdom. It was just part of our evolution. And so that's why we don't see those things there.
So the money things is like, as I read it, is interstate trade. So it is to stop at borders, customs duties and excise duties. If you say went from Queensland to New South Wales, previously the Queensland government could, basically tax things at the border. And one of the things that the Constitution does is it removes that. Am I correct in saying that?
Yeah, that's right.
Yep.
But it is funny that we have, as a right in our constitution, freedom of interstate trade and commerce, but you won't find written down anywhere there, the right to vote or a right to freedom of speech or those sorts of things. They're not expressly put there because that's not what was on the mind of the founders.
Which is interesting because when I read my 5-minute Wikipedia expert reading, is that some of the Bill of Rights things which we you see come up from really radical people from every now and again, is that in the Constitution it's not there explicitly but it's there implicitly. Like it says there will be popularly elected lower and upper houses constituted in a certain way, which implies that people will have the freedom to vote. Would I be correct in saying that it's not just doesn't just have to be documented; it can be interpreted through the way it's read. Am I correct in that?
Yeah, that's true. And the High Court during the 1980s in particular, when Anthony Mason was the Chief Justice, really was willing to imply those various rights and freedoms in the Constitution, which, although you could argue had always sort of been there as part of our system, had never really been clearly articulated until the Mason Court.
Okay, and so with different, maybe I'll just keep going here because we have to describe what the High Court is and how it fits. So the Constitution was actually passed not in the Australian, there was no Australian Parliament, it was actually passed in the UK Parliament in 1990, and 1900 I should say.
Yeah, that's right, 1900, yeah.
Yeah, and Sir Edmund Barton, our first Prime Minister, negotiated a subtle change whilst he was in London at that time, which was allowing the Privy Council to be the highest court that we would go to. So what was the Privy Council?
The Privy Council was, and still is actually, the highest court for all the English colonies. So, and it's constituted by the same judges who make up the House of Lords. So if you have a dispute in England, a legal dispute, it can appeal up through the process to the House of Lords. The same judges that sit on the House of Lords also sit on the Privy Council. But legal problems or legal matters that arise in the Privy Council don't come up from within England, they come up from within the colonies. So, previously Australia, Canada, to this day, for example, things like Brunei can find themselves wound up in the Privy Council.
And I believe there's a similar thing with Nauru, that they can raise issues in the Australian High Court.
Yeah, that's right. Actually, there are some instances where other countries can raise matters to the Australian High Court. It doesn't practically happen very often, but there are some instances of that.
Okay, so from 1900, this is passed in Parliament, and with it in a year, as it's written, we're a federated set of states. With a federal government. Now, whilst you mentioned a lot about transferring of money was one of the key things, is that the original federal government didn't have a lot of money. In fact, Barton is reported as living in Melbourne, where the first Parliament were held in Melbourne, living actually in the Parliament building in his own little flat where he cooked over an open fire his billy tea. So we weren't that rich at the beginning. I just found that quite quaint when I read that. Then in 1927. Essentially, the UK Parliament changed some verbiage, saying instead of the King, let's say King Edward was the King in Australia, he was the King of Australia, and this changed the concept of a dominion to being a separate almost entity in the Commonwealth of Nations, which has an interesting effect. And I hope I've got my dates right there, which is it was sort of part of the Statute of Westminster.
Statute of Westminster, that's right. Yep.
Then Australia didn't ratify that in its own law because we weren't under the UK law. We had to basically sign that up in 1942. So essentially, up until 1942, we were still a dominion of the UK.
Yes.
Wow. Now, let's fast forward to 1986, actually a year I can remember, but I know Peter probably can as well. Is that when we actually severed the relationship with the Privy Council. So the High Court in Australia was the final arbiter of laws. Did that involve a constitutional change, or where was it a referendum that changed that?
No, the Australia Acts in 1986 basically got rid of the final avenues of appeal up to the Privy Council. So over the years preceding 1986, we slowly took away the matters that you could appeal to the Privy Council. But finally, with the Australia Acts in 1986, which was an act passed by the UK Parliament as well as by the Australian Parliament, we got rid of those appeals, which made the Australian High Court, which was its creation of which was set up in our Constitution, finally, the ultimate court of appeal.
Yep, and so that sort of changed what was from 1901. So we really, for 85 odd years, we still had these legal ties, and obviously there's the constitution ties, but legal process ties to the UK, which a lot of people don't realise. And we still have the Queen's representative in Australia, the Governor General, as per the Constitution. And that person is, as per the Constitution, is the person that has control over the military, over the Air Force, the Army, and the Navy.
But again, the unwritten convention is that the Governor General acts on the advice of the Prime Minister and Cabinet.
Okay, and that's a convention which also works in the UK. The Queen, in a similar way, doesn't really, or as far as we know, doesn't influence when they decide to go to Iraq or wherever.
That's right.
But she's consulted in a politically correct way. I suppose that's the right thing, isn't it?
Yeah, that's right.
Okay, so let's sort of, I'm a Republican, mostly thanks to two formative movies that I saw in the early 80s, Gallipoli and Breaker Morant. Maybe that's a topic for another day, but the military stuff we did last week. Now, there's also been some talk again via various people that Australia should become a republic. How big do we need to have a referendum, or can someone just sort of sign a piece of paper and make it happen? Can the Governor General just say now let's just bugger off in the UK and make ourselves a republic?
Yeah, no, you would definitely need to have a referendum to change our constitution. So the way that it would work is we'd basically draft up a new constitution, and we'd have just a straight up and down vote, really. Do we want this new constitution or not? And presumably that new constitution would get rid of all the references to the Queen and to Great Britain, and then we can go from there. But yeah, we just can't do it. We have to go to a referendum. Our current constitution sets that out as the procedure. And there's also some school of thought that we might also need an act of the British Parliament as well, just to 100% make it clear. But that's a more difficult debate as to whether we'd need that. But we definitely need a referendum.
Yeah, and we can't do a Fiji where we freeze the constitution. Someone could freeze the constitution, but that's a pretty major thing happening in the country, isn't it?
Yeah, that's right. Well, that's not the way we like to do things.
Yes, well, not in this country at least. We're not. We were almost a banana republic in the 80s, but we're not anymore.
Yeah.
Well, at the moment. Okay, it was interesting actually that we, potentially just to close things off, we would have to, do some stuff in the UK, which I hadn't actually thought of the implications of that. So we can't just bugger off; we have to do some work. Now, in 1999, when we had the referendum after the our constitutional convention, obviously politically it was made to be unpalatable, or at least that's the argument that it was made unpalatable for people to have the republic as described from that convention. Do we have to? Would there be two, or would it just be one referendum saying we're going to be a republic and this is the constitutional change? Go to this website to review it, and just on this little piece of paper say yes or no. Is that fairly how the mechanism would work?
That's the likely way that it would work. It would just be, here's the full copy of the Constitution. You can read that for yourself. You can view it on the webpage or whatever, and there'll be a straight up and down vote, yes or no. I mean, there has been talk by the Prime Minister, Kevin Rudd, that he would put the model to a plebiscite before that, which means that we would go and have a vote as to what sort of model we would particularly want. But a plebiscite, unlike a referendum, is not going to be binding. But it would certainly give the government an idea as to what particular model would stand a chance of getting up.
Okay, so how does a referendum become successful in Australia? Because out of the 44 referendums we've had since we were became a country, only 8 have passed.
For a referendum to be passed, you have to get a majority of votes, and you also have to get a majority of states. So it means that you have to get over 50.001%, nationwide, and you also have to get 4 of the 6 states as well to have a majority in support of that change. Which
now, on the concept of states,
it's quite hard to do.
Yes, as the statistics show, 8 out of 44. So what about ACT and Northern Territory? Now, they aren't states. In fact, South Australia gave back Northern Territory back to the Commonwealth government in the early part of Federation. Why aren't they states? Why are they territories? And what does that really mean?
Well, they're territories rather than states because they haven't wanted to become a state yet. There is a process in our current constitution that would allow them to become a state. Section 124 of the constitution talks about the formation of new states. And a few years ago, the Northern Territory actually had a vote as to whether they wanted to become a state. And they chose not to. Now, what that means as a practical matter is that the federal government has a much greater degree of control over the territories than they do over the states. And yeah, that's the main practical difference.
Okay, so the Constitution it seems to me a fairly cleanly written document. It doesn't seem overly legalese, which I found surprising.
Yep.
Would that be your assessment? Compared to some of the more other legal documents, legal or laws, or legislation that I've read in my time, it seems quite clean.
No, I'd agree with that. It's not an exciting read, but it's a fairly clean and straightforward read.
Okay, and so I'm just flipping through my notes here because I might come back to this. So in our court system, we have different state court systems for state laws.
Yep.
And then we have a federal court which generally deals with crimes and cases involving the Commonwealth government. Is that correct? Federal court
the
cases?
federal court deals with matters of federal law as opposed to matters of state law.
Right, that's probably a better, cleaner way to put it. So I failed that answer. I'm just going to change my notes here as I go. And then the High Court of Australia is the last court in Australia for all court cases, not just constitutional questions. Is that correct?
Yep, that's right.
Yep.
And that's different, for example, than the US Supreme Court, where there has to be a constitutional issue for it to get there. Matters of pure state law in the US can't find their way to the US Supreme Court. Whereas in Australia, matters of pure state law, something like contract law or torts law, can find their way to the High Court, and frequently do.
And obviously, those that are contesting that, to have a lawyer, representing you is quite expensive. I think all Australians would be familiar with The Castle, the movie The Castle,
yep.
where Charles Bud Tingwell, stands, and doesn't just talk about the vibe of the law, but he, has his own little Marbo in place there. Now, High Court lawyers are generally, some of the more well-paid, or constitutional lawyers are more well-paid. Would that, and sort of my, the perception I have as just a general Australian is that, they do seem to be, a little bit more on the ball. That's my observation. Maybe not yours, because obviously they're your colleagues. But
High Court lawyers are on the ball.
Yeah, well, seem to be, dealing with deeper, bigger issues, which is why you're doing constitutional law, I suppose.
Yeah, no, that's right. No, it is. They're big, complex issues that get argued before the High Court by those sort of top silks usually, and so they're very experienced.
And so, because we see the escalation of state issues, for instance, one of the things that Avril, hello, hope she's watching this evening, and I've been through is in New South Wales, the Consumer Tenancy Traders Tribunal, which, if you disagree with their decision, you can obviously go to the New South Wales Supreme Court, and obviously, that could, if you've got enough money, be escalated into the High Court. They could obviously choose to reject it or not, depending on what you're appealing or what you're talking about.
Yeah.
I found that very interesting, that the High Court was dealing with a wider range of issues. Now, that isn't constitutional law, which we're talking about this evening, but it was just an interesting observation of the High Court that I made last night.
Yeah, and it makes being a High Court judge an incredibly challenging process, because you have to have such an extensive knowledge of all sorts of different areas of law at both a federal and a state level. So the sorts of work that they do is very, very diverse and very, very rigorous.
Okay, so a couple of interesting sort of parts to the Constitution is, I'm sort of reading this out, is not that I remember these off by heart, but Section 92 about trade and commerce between states should be free, which we talked about a moment ago, and also a lot about the executive power is held in the Queen's representative, and we'll sort of finish off on a case example of that. But one of the things I know that we had discussed historically, I think when we were at the Microsoft conference in February, was the Great Firewall of Australia, as proposed, a constitution? Was it constitutional? So, what's the thinking? Why would you go through that thought process to come to that point?
Well, there's a couple of different aspects to that. The first thing that you might want to argue about is there a Commonwealth head of power? Is it a matter over which the Commonwealth has the power to make laws? And that's probably fairly easily solved, and in terms of that it is. And that's because Section 51 of the Constitution, that lists all the subject matters, all the areas where the Commonwealth can make laws, includes paragraph 5, which is postal, telegraphic, telephonic, and other like services. And that phrase, other like services, has been held to, include things as basic as, radio and television, and sort of now the internet as well. The broader issue then would be whether it would violate our implied freedom of political communication. So although we don't have, an express freedom of speech set out anywhere in our Constitution, the High Court has held that there is this implied freedom of political communication. And there might be an argument that, Conroy's Great Firewall could fall foul of that particular implied freedom. The problem would be that certainly as it is drafted, or presumably as it will be drafted, it's not in any way trying to touch upon political matters, which means that even if you were able to establish that it might, infringe a broader freedom of speech, that doesn't equate to our very limited implied freedom of political communication. The final aspect on that, which I'll just also mention, is that there is an argument as to whether it has to be done by legislation or whether it could be done just by regulation as well. And that's also touches upon some constitutional issues.
So there are two things that I've sort of thought of as you were talking about there was, in terms of the constitutionality of it, is if, let's say, someone badly drafted something and put it into a regulation which doesn't require an assent of the federal government to do, that can be contested in the High Court as being not constitutional. Would that be correct?
Yeah, that's right.
Yep. And so people could bring up a case to say, hey, this is not constitutional, don't do it, which was the story that happened about this second round of stimulus money that someone, I think someone, obviously not you, Peter, but
no.
Someone had actually was contesting the constitutionality of giving out
Yeah,
this money.
he was a constitutional law lecturer at a different university.
Not you. Yeah.
Not me, and not someone from...
Not from QUT. You still there, Peter? I can't hear Peter. Drop down. I'm just going to in Skype here. Yep. So we just dropped the call there for a moment. I hope you're finding this interesting. I know Fee Bendel has a question in regard to why do we have states, and that is a question I'm coming to actually in this little next section. So suffice to say, your questions will be answered. I'm just going to put this call into Peter, thanks to the magic of Skype. It's a lot that I learnt just doing my research into the Constitution and things that are written and things that aren't written. And it's interesting when Peter talked about the in terms of the Great Firewall of Australia, is that even issues like that potentially affect our lives, we might have recourse in constitutional law, which is something that I wasn't until he talked about it wasn't quite aware of. As you can probably hear, I'm still trying to call him. Yep. The other thing we're going to discuss before we finish is just another case study, which is a fairly important piece of Australian history, is what happened during 1975, and also the months and years leading up to it in terms of what it meant to our Constitution, and sort of ties together some of the things that we've talked about a little bit earlier in terms of reserve powers and conventions as compared to written down things. As you can see, I've had a couple of visits from the cats, so I think I'm now up for about four cans of food for them. That's the rider. Okay, so I'm gonna leave it just for a moment and just talk through some extra stuff. This is what happens, and this is why you prepare. Okay. So one of the things that that Fee asked about was why do we have states, and part of it is to do with that history of having states. But what's been happening over certainly the last, say, 10, 20 years is this move to federalism, or move to more of the power actually being centralised by the federal government. One of the key reasons why this has occurred is because the federal government in 1946 retained the right in terms of income tax. Before 1946, income tax was split partly between states and partly between the federal government, but after the Second World War, the federal government took it over. And there were some court cases in relation to that after 1946, even into the 1950s. Then in the 1980s, the corporations law, which used to be state-based, so you could have a company with the same name in two different states, but not being the same company, that was federalised or put into a national sort of system in the 80s and 90s. So we have the ASIC and ACCC formed out of that, and a much more national approach to laws across each of the states. So the federal government sort of created a template law that is then copied and pasted in each of the states, so everyone sort of works off the same sheet of paper. The other thing that requires federalism is, as we move to a much more global sort of world, and as Australia signs many more international treaties, whether it's World Heritage treaties, whether it's international rights treaties, that is then covered by a section 51 of the Constitution, which is about external powers, and suddenly the federal government has control over that. So we have ringing.
Hello.
Hi, Peter. Yeah. So I've basically one of the things I might point out for everyone is that I'm not a lawyer. I'm merely a bush lawyer, and none of what Peter and I talk about should be construed in any way as legal advice. If you need legal advice, please seek a proper legal counsel. We're just discussing the bigger picture stuff here. I feel like a lawyer saying that.
Yeah, no, have it down pat. Very professional, Nick.
Yeah, I've been spending the last 4 weeks actually, and we'll spend probably the next 4 weeks dealing with a lot of process and law in my day job, which I'm actually I enjoy. But when I start quoting the Trade Practices Act to people, they look at me quite scared because they realise some of and also their personal liability under the Trade Practices Act as well, not just corporation things. Is you can't do an invitation to offer. You can't say you're going to do something and then pull it off, because that's bad. That's misleading and deceptive conduct. I love the law.
Yeah, well done.
I should. Yeah.
I'm happy to confer on your law degree at the end of this.
No. Okay, so I was talking about the external powers, which is Section 51, Part 29. So this is in relation to external treaties. So we signed the World Heritage Treaty, part of the United Nations, which suddenly means that if Tasmania wants to burn or chop down part of their forests, suddenly the federal government can step in. Would that be an example?
That's right. If the federal government is able to find and sign an international treaty, the external affairs power has been construed to allow the Commonwealth then to make a law about the subject matter of that treaty, which inevitably expands the sorts of things that the Commonwealth government has been able to make laws on.
So with this creeping federalism, do you see or foresee that states become diluted to a point where they don't exist?
States, well, they'll probably never reach a point where they don't exist. Certainly they have been considerably diluted in terms of their power. The simple fact that now, the states are pretty much dependent upon the Commonwealth government for money. means that their influence and power is very different in 2009 than what it was in 1901.
Yep. So let's just, as a final case study, let's just talk about 1975, the dismissal. Now, there's actually two conventions that were broken here, if we think about it, or as I researched it, I should say. It was firstly Queensland's Joe, so this is your fault, essentially putting into the Senate, because someone from Queensland was no longer in the Senate, so he put in someone who didn't really like Gough Whitlam, who was the Prime Minister at the time. And the same thing happened in New South Wales, so it's not just Queensland's fault. And this is and put in someone who wasn't from the original party, which broke convention. And so what occurred then was the withdrawal of supply. So the Senate did not ratify the government's money bill, so that essentially the government wasn't going to get any money. And so there was this friction between both houses of Parliament by withholding money, withholding supply.
Yeah.
And what happened, as I understand, for the first time since 1834, is that the Governor-General dismissed the executive government. So the unelected Governor-General kicked out the elected Australian government of Gough Whitlam.
Yeah.
And what was used there, as I understand it, was the reserve powers in these conventions. What has been the result of that, in constitutional law? Is it like a whole semester subject?
Well, we certainly touch upon it in a bit of detail when we look at executive power, which is obviously a fair chunk of what you do in a constitutional law unit. But what's interesting about it, there's lots of things that are interesting about the dismissal, but one of the things that's interesting about it is that it was never actually litigated. It never actually went to court. So there's not any clear, legal principle or significance that you can take out of it in terms of what is a rule for the future. There's lots of debate and discussion you can have around it, but there's not one sort of clear legal rule to be able to take out of it. But just because so many conventions broke down. I mean, obviously Joe, when appointing the senator, didn't comply with that convention. The convention that you don't block supply, that you pass supply, was also broken. The convention that the Governor-General acts on the advice of the Prime Minister and Cabinet was also broken. The convention that the executive, the Governor-General, also the Prime Minister doesn't consult with the High Court, whereas that was out the window as well, because Sir John Kerr consulted with the Chief Justice, Sir Garfield Barwick. It's just series, just one after another. The constitutional conventions broke down. It never got litigated, perhaps because it never really, it could be. Once you have the Chief Justice, Sir Garfield Barwick, already expressing a view on it, it would be very hard for the High Court to then hear that matter. But also because ultimately, it resulted in an election. And, in a democracy, it can't be that bad a thing. If even when everything collapsed, what did we do? Well, you had an election and the people then decided.
Yeah, and the Constitution didn't break down. We didn't have people in the streets and the army in the streets, battling,
That's
like
right.
we see in other countries that do have stronger issues. So really, I want to thank you, Peter, because we've got Plinkies coming up soon, which we're all sort of hanging out for. Thanks for helping me out and actually not forcing me, but putting me through the learning process of understanding how the Constitution works.
Yep. No.
So thank you, Peter.
Yep. Thanks, Nick.
I'd like to thank the Crazy One for helping us with some of the back channel stuff and helping us there. Next week I have another show with Stephen Collins, otherwise known as atTrib, on Twitter, which is going to be called The Theology of the Clue Train, which is sort of re-highlighting some stuff I covered a few weeks ago, and also sort of some thematic stuff that I've seen appear certainly in the Twitter stream and in the social media world. So that's going to be an interesting look and discussion of that. So with that, we will put on a bit of music and allow you to turn over to Stilgarian Live. Thank you very much for listening and being a wonderful and patient audience whilst we reconnected the interwebs there for a moment. And let me just swap this over and we will see you all next time.
sounds of then, and people talking seems recalled by minute movement and songs that fall from a backing tape, a certain texture, that certain smell. To lie in sweat on familiar sheets, in big veneer on finance beds, in a room with silent hearty flakes, a certain texture, that certain smell brings home the heavy day, brings home the nighttime swell.